voters in Kansas refuse to amend their constitution in light of Dobbs versus Jackson Women's. Good afternoon, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. Yes, that's right. Kansas voters had before them yesterday a proposed amendment to their constitution intended to nullify a 3-year-old Kansas Supreme Court decision. Well, as a result of it, and then it failed, and as a result, women in Kansas may still end their pregnancies at least up to 22 weeks, and the legislature may pass no laws any stricter than those they already have. And already the spin doctors are hard at work. We're going to talk about how the Kansas Amendment read, and though I won't quote it exactly, I hope to show you that it was fatally ambiguous. We're also going to say a few words about the current state of Kansas law and what the pro-life side in Kansas and in other states like it must really do to advance their position. In other words, what can they learn from the failure of the Kansas Amendment yesterday? Before I get into any more detail, I do want to shout out to the sponsor of this channel, which is Conservative News and Views. Link in the description. Be sure to check out the awesome CNAV Store. Scroll down near the bottom for that link. Lots of good merchandise there, including this t-shirt that I selected for today, which reads, "Not your body, not your choice." That amendment did not make that as clear as it should have, as I hope to show. The amendment would have set up a new section of the Kansas Constitution, Section 22, and it would talk specifically about how to regulate when and how a woman can end her pregnancy. Now, that kind of heading is probably not a good idea to begin with. Here is the text, which I quote loosely. "Because Kansans value both women and children, the Constitution of the state of Kansas does not require government funding to end a pregnancy and does not create or secure a right to end a pregnancy either. To the extent permitted by the Constitution of the United States, the people, through their elected representatives and state senators, may pass laws regulating that practice, including but not limited to laws that account for, well, let's just say that it's mentioned the 3 big hard cases. If you want the rest of the text, I have a link in the description to a human readable image so that you can read it for yourselves. Eric Woods Erickson tells us, and I think he's right about this, that many voters likely found that wording ambiguous and its intentions far from clear. The actual impetus for the Kansas Amendment was a Roe-like ruling in 2019 from the Supreme Court of Kansas. In Hodes and Nauser versus Schmidt, the court held, and I quote, "Section 1 of the Kansas Constitution, Bill of Rights, affords protection of the right of personal autonomy, which includes the ability to control one's own body, to assert bodily integrity, and to exercise self-determination. That right allows a woman to make her own decisions regarding her body, health, family formation, and family life, decisions that can include whether to continue a pregnancy." Unquote. I've left a link in the description to the PDF file containing the slip opinion from the Kansas Supreme Court in that particular case. Now remember, slip opinions are the opinions waiting for someone to slip them into a law book. And by the way, that opinion runs to 199 pages, counting syllabus, opinion of the court, concurrences, dissent. Now, who were Hodes and Nauser? Well, they were gynecologists challenging a law forbidding a second trimester procedure called dilatation and evacuation. Now, I flatly refuse to describe it here. If you want the details, type that phrase into any internet search engine, only I would do it on an empty stomach. And this is exactly the kind of procedure Mississippi sought to forbid by cutting off the ending of a pregnancy at 15 weeks, leading to the Dobbs decision. The Kansas Amendment which supporters called Value Them Both, failed the passage, 60% to 40%. Proponents of the amendment merely said they would be back to try again. Opponents breathlessly declared that meant that Kansans celebrated what they called fundamental rights. Now, the very complaint some of them made against the Kansas Amendment belies that last claim. They said the wording was ambiguous, and it certainly is. It talks a great deal about what the Kansas Constitution does not require and does not secure. But the second sentence seems to imply a loosening of restrictions, not a tightening of them. For that reason, Mr. Erickson guessed that many pro-life voters voted against it because they thought this amendment would be a disaster for their position. And he's very likely correct. Erickson also predicted that the mainstream media would make too much of that result. First, he says, Kansas voters tend to stay in the middle of the road anyway, so they don't necessarily reflect the rest of the country. And second, Republicans cast 60% of the votes in primaries. The Kansas Reflector reported a higher urban vote and a lower rural vote than in the election of 2020. Before I get into other attempts at American history to resolve a problem like this with a federal constitutional amendment, I want to shout out to another sponsor, BitNext. This is your replacement for Zoom, Slack, the Google G Suite, Microsoft Office 365, Dropbox, WeTransfer, and Chili Piper, among others. Unlike any of them, BitNext protects your content and conversations so well, even the administrators can't see it. So this is your channel for secure comms, conferences, cloud storage, and file sharing. Best of all, everything is back-end. You don't even need client software. If you have a browser, you can use BitNext. Follow the link and give them a try. 28 days free of charge. You can't beat that with a stick. Okay. Now, the failure of the Kansas Amendment recalls the first time someone tried to amend away a bad decision by another Supreme Court. During the 98th Congress, Senator Jake Garn of Utah proposed a Human Life Amendment, labeled SJR 4. It would have said flatly, and again I quote, "With respect to the right to life, the word person, as used in this article and in the 5th and 14th Articles of Amendment to the Constitution of the United States, applies to all human beings, irrespective of age, health, function, or condition of dependency, including their unborn offspring at any stage of their biological development. No unborn person shall be deprived of life by any person, provided, however, that nothing in this article shall prohibit a law permitting only those medical procedures required to prevent the death of the mother." Unquote. I've left a link in the description to the article by the Catholic Television Network, EWTN, describing Jake Garn's proposal and several other proposals of various kinds. Now, Jake Garn's amendment didn't even muster 2/3 of both houses of Congress, but at least it defined the word person in crystal clear language. Now, contrast that with the Kansas Amendment. It tries to duplicate the result in Dobbs versus Jackson Women's Health Organization. The Hodes court, for lack of a better term, would have to search elsewhere than in Section 1 of the Constitution of Kansas to invalidate this. But they could use one of the Bill of Attainder clauses of the federal Constitution, and specifically Article 1, Section 10, Clause 1. They could simply say that this section declares women to be outlaws subject to a special penalty. Recall what Barack Obama said to articulate his anti-life position. You know the famous words, "Why should she be punished with a baby?" The problem for right-to-life people in Kansas is that ending a pregnancy is not an all-or-nothing proposition in Kansas today. Current law and regulation in Kansas restricts pregnancy ending after the 22nd week, requires notification of the parents of any minor who wants to end her pregnancy, and requires the observance of a waiting period. Regulations like these reflect what the Casey precedent allowed. Now, of course, Casey is no more. Dobbs put pay to that. But in order to protect human life property, you must define an explicit right to it. The Kansas Amendment would not have done this. The Value Them Both Coalition chose to use ambiguous language. Maybe they wanted to sound reasonable, but hey, those who stand for the truth should not play that kind of game. You don't stand for the truth by lying or dissembling. Now, the urban-rural spread on this vote tells us that the Value Them Both coalition grew complacent on at least one count. They thought they actually had the hearts and minds of enough people in Kansas, and they thought wrong. Now, there might be more to it than that, but that was enough. And that is the big problem. Hearts in Kansas would appear to be still hard and minds closed. That described political feeling in 1973. And even 10 years later, when Jake Garn proposed his own amendment. And not only Jake Garn, but Henry Hyde, the National Right to Life Committee, and many others. The Right to Life side had to learn patience. So they patiently sought to convince people that the very act of ending a pregnancy before term, for reasons other than to save the life of a mother, was wrong. And furthermore, that the typical methods for ending a pregnancy sullied the medical profession and coarsened society in general. Now, I've been over this before, many times. Ironically, the anti-life side might have eroded the foundation of their own position. They didn't keep their children. Pro-life people kept theirs. So the second and third generation of voters included ever more voters raised in pro-life homes. These voters elected Donald J. Trump in 2016, and he critically replaced Justices Anthony Kennedy and especially Ruth Bader Ginsburg. Their replacements gave us the Dobbs decision and the Carson and Kennedy decisions. But Kansas is where the country was in Jake Garn's day, and Dobbs is incomplete. Dobbs specifically avoids making any universal moral judgments. That's why the pro-life side must argue on behalf of the unborn. They must argue in the court of public opinion and in a real court. Imagine a case like unborn child x-ray versus Hodes and Nauser. And they must press that kind of argument as long as it takes, and not with the ambiguity we saw with the failed Kansas Amendment. Link in the description to the article, to the image of the Kansas Amendment, to the opinion in Hodes and Nauser versus Derek Schmidt, to the discussion of Jake Garn's Human Life Amendment and similar proposals, and to conservative news and views. I have another link to the awesome online store and to BitNext, as I also mentioned. And if you like what you've heard, you can like this video. On the end screen, I'm going to leave a subscribe link and also a link to my pro-life playlist. This is Terry A. Hurlbut delivering another declaration of truth and reminding you to let the truth set you free.